All right, let's get underway. Welcome everybody to our webinar today, covering the topic of employers managing their workforce effectively through COVID-19 as it relates to JobKeeper and casual employee utilisation and what to be aware of. My name is Wayne Baker. I'm the CEO of Symmetry HR. I've been at Symmetry since 2011, and Symmetry HR provides solutions in recruitment and HR for businesses nationally in manufacturing and logistics, hospitals and aged care facilities, contact centre and all office and managerial based roles. Our aim is to understand so that we can then support you in the best way possible. It's great to have everybody in attendance. I'm looking forward to what the webinar can bring today. Just to give you a little bit of a snapshot in terms of what we will be covering, just to get a couple of points there and over the next hour. So first of all, what do the JobKeeper changes mean to employers with casual staff on their books? Number two, how can you manage your casuals during the COVID-19 downturn so that you're still in business to rehire them when things pick up? And three, how can you calculate your exposure to claims from casuals who might get reclassified as full-time workers under the Rossato versus Workpac federal court ruling? Couple of housekeeping matters before I introduce our special guest. All questions that have come through the chat box, which is including technical ones, which we'll obviously look to deal with as quickly as we can. And of course, most importantly, the topic-based questions. There will be a Q&A with myself and Nick at the end of the presentation, where I will be drawing questions from the chat box that you, the audience, has provided. So let me introduce our special guest, Nick Tindley. Nick is a partner with FCB Workplace Law and the Executive Manager of HR Consulting and Advisory Services at FCB HR. Based in the Melbourne office, he has over 12 years experience in providing industrial relations and employment law advice. In his role as Executive Manager, Nick oversees both the consulting and advisory teams at FCB HR and is responsible for managing a number of key client relationships. Nick also manages the advisory services for the Australian Retailers Association and also an association that I'm a part of, the Recruitment and Consulting Services Australia Association, the RCSA. And also he manages the Victorian Association for News Agents and Fitness Australia. Nick participates in the Workplace Policy Committee of the Australian Chamber of Commerce and Industry and facilitates the RCSA's Workplace Relations Working Group. On a personal note, Nick loves to get away to Peterborough, which for those that don't know is about 3 hours from Melbourne on the beautiful Great Ocean Road on the southeastern coast of Victoria. And finally, he is also, I'm not sure how this will go across, but he is an avid follower of the Collingwood Football Club in the AFL. I welcome Nick Tindley. Thanks, Nick. Welcome to the webinar.
Thanks, Wayne, and for the occasion, if you can see, I've got a black and white pen. So, there we go.
Yes, well, we'll see how that goes over in a Saturday week, I think, where the Pies are on. So we'll see.
Yes, yes. Good luck to them, I'm sure everybody thinks.
We'll need it, yeah, exactly. Look, good luck today. And as I say, I'll hand the baton over to you, Nick, and I'll speak to everybody at the end of the presentation. Good on you, Nick.
Thanks, Wayne, and thanks everyone for attending. We know it's a very interesting and challenging world that we're navigating through at the moment. And what we're hoping to do today is to just step through with you some of the things that are important and also changing. We know that JobKeeper is developing. If we jump onto the next slide, I'll sort of set out the way that we're going to deal with this. So we know there's been an extension, and that is pending. I think the old JobKeeper system ceases on Sunday, and the phase 2 starts on Monday. So hopefully we're all aware of what that means for us and are ready to respond to it. We'll talk about what I think will become more pressing, which is the interaction between JobKeeper and entitlements. As Wayne foreshadowed, we'll also talk about this kind of connectedness with your particularly a casual workforce in a COVID world, it is an interesting area, and it does, I guess, to some extent extend to all of your employees, because it is difficult to retain that connection where kind of hours have been reduced or work stopped completely, or people are just working in vastly different ways with less and less people around them. And as Wayne said, we'll look at the casual employment risk factors, and that really relates to what level of risk each business faces with this definition of casual employment issue that's arisen through the couple of Workpac decisions, being Skeen and Rossato. So we'll just jump on to the next slide and get into the JobKeeper area. So we know that on the 1st of September, some legislation was passed which extended JobKeeper. It did two things. So it extended the payment, the JobKeeper payment structure in quite a different way, and it also extended in quite a different way the temporary changes that were made to the Fair Work Act, which gave employers a whole heap of powers in terms of changing the way employees work to respond to the challenges of the pandemic and its impact on employment. I'll start with the JobKeeper provisions of the Fair Work Act, because they're quite pressing and quite important. Whereas under the first phase of JobKeeper, you had eligible employers and ineligible employers, and only eligible employers were relevant. Moving forward, there's two categories of employers. There's what's called qualifying employers and what's called legacy employers. And so qualifying are those who are eligible after the 28th of September, regardless of whether they were eligible before. And legacy employers are those who were at some point eligible in phase one, but are no longer eligible in phase two. So we'll jump to the next slide. So a qualifying employer contain or retains most of the entitlements or rights that they had under the first wave of JobKeeper in respect of the Fair Work Act, and that is that they can continue to issue the JobKeeper enabling directions that they previously issued, and those are directions to work less hours, carry out different duties, work at different locations, and a right to ask the employee and to work on different days or at different times to what they'd usually work, and that the employee could only reject that on reasonable grounds. The only substantial limitation that qualifying employers have is that previously they had a raft of rights in terms of requesting employees to take annual leave, and having those employees only be able to reject those requests on reasonable grounds. If we go to the next slide. In terms of annual leave, there is, whilst you've lost what I think is a level of authority in terms of, I want you to take this leave, or I want you to take double leave at, leave at half pay. There's now, those have been removed, but you can still reach agreement with employees about leave being taken, and you can still achieve the sorts of, or you still have the same rights that you had under the Fair Work Act generally about directing leave in particular circumstances where excessive leave balance or shutdown of business operations. The really critical thing with this, and it's quite pressing that this be done, is that if you are a JobKeeper eligible business and you issued a direction under the Fair Work Act under the first phase of JobKeeper, and that had a cessation date of the 27th of September, which a large number of them did, you'll need to reissue that correspondence with appropriate dates. And because the Fair Work Act requires that where a direction is given, there be consultation and that there be notice of 3 days before it commences. The unfortunate thing is that means you need to do this today. So please stick around for the rest of the session. But if you haven't done that, I'm sure you'll be scrambling to get that done quite quickly. Legacy employers are a very different proposition. So they are businesses who had access to JobKeeper in phase 1, but because of changes in their business performance, are no longer meeting the eligibility test for JobKeeper, but they're still experiencing a decline. So a legacy employer, in order to access some of the JobKeeper flexibilities under the Fair Work Act, needs to have a certificate issued by a financial services provider, which states that they've experienced a 10% decline in turnover. So we'll know that for most businesses, the decline to access JobKeeper 1 and indeed JobKeeper 2 is a 30% reduction, unless you're a very large business or a not-for-profit. For a legacy employer, you can access this if you've experienced a 10% decline in turnover. What does it mean? It's certainly a modified, the modified version of JobKeeper 1. So it allows directions in relation to duties and location of work and requests to work different days and times of work, provided the request doesn't require them to work less than 2 consecutive hours. But in terms of the reductions in hours, which is probably the most frequent direction that we saw being given in the pre or in phase 1, there's a limitation to the amount by which you can reduce someone's hours of work. So for qualifying employers and under JobKeeper 1, you could reduce down to nothing. Under JobKeeper 2, if you're only a legacy employer, you can only reduce an employee's hours to no less than 60% of what their ordinary hours were at 1 March 2020. And again, can't be required to work less than 2 consecutive hours in a day. There's a slightly different but critical change in terms of notification and consultation obligations for legacy employers. They have to give 7 days written notice before issuing a direction, and there are some additional consultation requirements placed on them. The way that access to JobKeeper is assessed is slightly different moving forward. So in the first 2 rounds in the first round of JobKeeper, there were what you were required to do was to project your turnover decline, and it was based on estimate rather than actual, and it was a one-off test. So once you were in, if you satisfied the test in the first month of JobKeeper or the first quarter of JobKeeper, there was no ongoing assessment. Now that's that there is a 2-stage test, and it's based on actual turnover rather than projected turnover. So you need to get your revenue, your BAS revenue for the September quarter, and you'll need to do that again for the December quarter. So the September quarter will get you through till close to the end of December, and the December quarter will get you through to 28th of March. Test value is the same. So as I'd said before, businesses with turnover less than $1 billion, it's a 30% decline. $1 billion or more, 50% decline, and 15% for registered charities or not-for-profits. So the main things to note: need to requalify, reduction in turnover assessed against a comparable period. New recipients can apply. So businesses, I mean, Victoria is probably one of those kind of exceptions to the rule is that businesses may not have seen as substantial a decline in the past 6 months as or in the first 3 months as they're likely to see in the September quarter, and so but there may be new recipients eligible. So turnover is calculated as it is for GST, and one of the complications for it is that you have to try to assess your JobKeeper eligibility ahead of the BAS deadline for GST kind of turnover. So there is still a little bit of predictive nature of it, but it's important that you kind of calculate that as accurately as possible. Next slide, there we go. So there's three kind of categories or groups of eligible employees. There's ongoing eligible re-employed employees and newly eligible employees. For all of those, and the most, I think, substantial change to JobKeeper is in terms of the value. So you can see there that there is a step back process being implemented, and different categories of payment based on average number of hours worked. And you can see there that we've got the note that hours worked is determined by the average hours worked in the 4-week period before 1 March 2020 or 1 July 2020. So you assess those and take the higher of the two. So an ongoing eligible employee, employed on or before 1 March 2020, currently employed, including stood down or re-employed, permanent or long-term casual. So they are employed on a regular and systematic basis for at least 12 months as at 1 March 2020, or at least 18 years old on that date, or if they were 16 and 17, were independent and not undertaking full-time study. Australian citizens or permanent residents, or that very limited kind of New Zealand visa category exemption, Australian resident for tax purposes and not in receipt of a JobKeeper payment from another employer. Re-employed employees, so they must have qualified for JobKeeper at 1 March. They ceased employment between 1 March and 1 July and were re-employed after 1 July and continue to satisfy the eligibility criteria. And the employer is not at any point nominated for JobKeeper payments with another employer, and that's an area of some level of controversy. I think there have been some people who have double dipped on the JobKeeper payments. So there was, however, a fairly important shift in relation to newly eligible employees. There was always that controversy of employees who were employed after 1 March 2020 were unable to access JobKeeper, or who hadn't had 12-month service as a casual on a regular and systematic basis at 1 March 2020. And there were lots of, fairly, I won't call them heartbreaking, but difficult stories of employees who, started work on the 3rd of March, therefore didn't get JobKeeper and were stood down without pay. There's been a shift so that if there's essentially a new date, so all the criteria still apply, but the new date of 1 July 2020 is the landmark or milestone for people. So if someone was commenced work in June 2019 as a casual and worked on a regular and systematic basis, they would have at least 12 months service as at 1 July 2020, and therefore they are now eligible for JobKeeper. Similarly, a permanent employee who was employed after 1 March but before 1 July will have that access. All the other criteria are exactly the same. We'll go to the next slide. So that kind of sums up the JobKeeper world. I think I'll just quickly give you a summary of that, in that I think it's really important that you make sure that if you are still JobKeeper eligible, that you make sure that your communications, if you have and are going to continue to stand some people down or have issued and are going to continue to issue JobKeeper directions, that you either reissue them if they had an end date in their first iteration, or if you're issuing directions to any new employees, you make sure you're complying with the notification and consultation obligations. That obviously extends to those who aren't getting the payment anymore, but still want to access some of the Fair Work Act flexibilities. One of the other challenges that I think, or one of the key challenges that's arising with COVID and employment is just how you maintain connection with employees and don't lose skills where substantial changes have had to be implemented. Just before stepping into this, I was doing an unfair dismissal response, and it was where an employee had been made redundant, and the person who, this is a relatively small business, but the person who implemented the redundancy had never met the individual who was made redundant. That individual had been employed for 5 years, but the person who I guess communicated and made the decision had been employed for 6 months. But because of COVID, they'd been working, but the employee was made redundant, been working from home. They never actually had a face-to-face interaction. It was one of the, whilst it's, to be honest, completely irrelevant to the unfair dismissal consideration, it was something that the employee was frustrated about, and that did kind of solidify my thinking on the importance of maintaining that connection. And it's important both from ensuring that people are engaged, working productively if they're working remotely, working productively if they're working reduced hours, but also, and particularly with casuals, that risk that exists that you're going to have them not stick around with you. So we know that casuals predominantly are looking for as much work as they can, and if you've been placed in a position where you've got to reduce hours, your normal response is to cut back casual hours much more aggressively than permanent employee hours, and that's going to create, I think, a challenge when we move back into our net, hopefully as normal, at least as near to normal as we can get, because if you've had casuals that worked with you for a reasonable period of time, they've built up the skills and knowledge of working with your business, which, as we know, every business operates at the very least in some ways differently, and in a lot of ways substantially differently. If you lose those resources, you're essentially back at the start in terms of building those skills. And we're seeing employers do a range of things, and it was really founded. Some of the things we're seeing have been really founded on this idea of everyone's in this together. So there's been for a lot of employers just a sharing of the burden. And a reasonably consistent reduction across the workforce that's impacted most people in a fairly similar way, rather than having substantial impacts on individuals and not on others. We're seeing some employers looking at, I guess, kind of sharing employment. We know that there are a raft of individuals working at places like Qantas who ended up being allocated across to businesses like Woolworths to help with meeting the demand, the grocery demand that occurred, particularly at the start of the pandemic, and then again when we had our second wave in Victoria. And we've seen labour hire having a significant role in this. A lot of the deployment across the supermarkets was managed by labour hire firms, and where essentially they're almost taking a caretaker role for the employees. And for Qantas, there was still a level of connection between them and those employees, but they were almost like seconded across to to Woolworths. So there's different ways that businesses are responding to that, but I think that the main point is to have an eye on those kind of skill issues, because I think everybody knows that the time taken, you would rather not repeat the time taken to bring a new casual employee up to the level of someone who's been with you for a reasonable period of time. That's all we wanted to say on that, and then I'm going to finish off with we did a session on this not so long ago, but it continues to be interesting and challenging. We know that a full court of the federal court on 2 occasions in the last 2 years has deemed employees who were employed on the basis that they would be casual, receive a casual loading and not receive permanent employee benefits to annual leave, personal leave, notice of termination and redundancy, being determined to have actually at common law be engaged as a permanent employee and therefore entitled to all of those benefits. And we know that that the estimates of the cost of this are kind of anywhere between $6 and $12 billion to industry generally. So there's a substantial amount of risk around this area, and so it's really critical that every business has undergone its own assessment of what its risk is. We know that there are auditors who are not signing off on reports unless the business can demonstrate what its casual employment liability might be, and so it's really critical to undertake these analysis. So the starting point, and something that will become increasingly important moving forward, is the contract of employment. So there are a couple of aspects to the contract that are quite important. One is the casual loading. Does your contract with a casual employee identify that a casual loading is paid, and does it identify what it's paid for? Does that contract make it clear that if the employment was deemed to be something other than casual, that the employer is entitled to offset casual loading against any leave entitlements claimed? And what I think will become increasingly the most important element is, does the contract support and communicate the casual nature of the role? Does it make it clear that there's no firm advanced commitment to ongoing employment? And does it confirm that the employee has the right to accept or reject work that's offered? So I think that there's an absolute imperative in looking at contracts of employment and determining are there changes that need to be made to those contracts. The next slide, and the next thing that we'll need to look at, is the hours of work. And this isn't necessarily about, well, I guess to some extent it is about the regularity of the work, but it is probably more importantly, it's about the way that work is communicated. So in both Skeen and Rossato, one of the compelling factors was that neither Skeen nor Rossato needed to have any engagement with their employer about when they were working. So that they were given the mines roster. They were both mine workers. They were given the mines roster, which was put out 12 months in advance, and they just worked on one of those swings within that 12-month roster. And so they never had any communication with their employer, which was a labour hire company, about the hours of work. And so that meant that this casual concept of, work on an as needs basis, ability to accept and reject shifts without punishment, right of the employer to offer shifts as they see fit, kind of fell away pretty substantially. And it certainly wasn't the mine that was in difficulty for that, although they would have been if they were directly employing the employees. The liability lay with the labour hire firm being Workpac. So there are, I think one of the critical things that you can do as a business to minimise risk is to communicate the hours of work that an employee is going to work. You're essentially enshrining and offering an acceptance element to the work that's being performed. So in an ideal world, and this requires having reasonably sophisticated systems, is that there be a communication out to the employee saying, here's the roster that we're offering you for this next roster period, and the employee being required to either tick yes or no to that roster. And if they tick yes, then they work the roster. If they tick no, then the roster's withdrawn, and there's a discussion with them about that. If you can't do that, then some other system of here's your roster, and if you come to work, you're deemed to have accepted that, then that's a reasonable alternative option. But you absolutely need to make sure that if you've got the contract that says this is what you've done, this is what the relationship's going to be like, and you've then got the practice that shows that the employee can reject and accept work, then you're at lower risk of deemed permanency. We've come up with some things that you should have a look at in terms of whether you think or whether there's any exposure within your business. I'll be clear that we've historically spoken about casuals with maybe kind of 6-month service or 9-month service being the risk area. I think it's to be absolutely certain, you need to shorten that period a bit, and then look at the nature of work more so than the length of work. So you look at the casuals who have got more than 3 months service. You look at first of all, do they have a contract? And attached to that does the contract is there any deficiency in the contract in terms of the things that we spoke about before? Have they worked in the same role at all times? Do you have little or no role in communicating the hours of work? Do they just turn up at 7:30 on Monday because they know that's when they start, and they do that Tuesday, Wednesday, Thursday, Friday? And then what is the level of fluctuation of hours of work across the employment period? So, there's a big difference between a casual who works 15 hours one week and 30 hours and 10 and 22 and has all of these sorts of changes, when compared to a casual who works kind of 30, 33 hours, 34 hours week in, week out, on the same days at the same start finish times. So that's the kind of risk assessment that we think is quite important for you to undertake. I think that brings me to an end in terms of the presentation, but I know there's likely to be some questions.
Thanks, Nick. Look, obviously highly informative. I just want to, at this juncture of the webinar today, I just want to highlight that there is a special offer today for all the people that are attending the webinar. It's a free audit of your business's casual workforce. It's conducted by Nick and myself, and it will step out the checks that you need to undertake to protect your business. So please write the word audit in the chat box to request an audit at a scheduled time. So again, I'll repeat that. Please write the word audit in the chat box, and we'll obviously get in contact with you with that free special offer. So that's really important, just to go through, your employees, your casual employees, and then there can be an analysis of your workforce. So thanks again, Nick. I'm just going to move into some questions here. But I just want to make a point. You made a really good point about casual employment and casual utilisation and how that extends to the risk to your skill retention and having to start over again. Symmetry HR, we have a long-standing client that's based in Victoria in the northwestern suburbs. And they have a sort of a roster where they run a product for 6 weeks through their production, and then they run another product for 3 weeks and they change over. So during that 6-week period where they're running product A, they require a lot of casuals, not so much when they're running the product B during the 3 weeks. So it's like a 6 weeks on, 3 weeks off. So there's a bit of a challenge there with maintaining or retaining the skills of the people that work there. So, and our casual employees. So this client is a really great employer. They've created an environment that the staff want to return to, and of course Symmetry have an agreement with them that they won't lose their staff. They'll work for 6 weeks at the client site, and then they'll hand them over back to us, to Symmetry HR, and we'll place them in other roles during that 3-week period. And as soon as our long-standing client requires them back, we will trigger a phone call, obviously, to each of those casual employees to return to that particular site, so that the method of skill and knowledge retention is maintained. And it's a really effective process. It's been going on for probably 18 months to 2 years now, and it's worked really effectively. And both parties are committed to making it work. But it's dependent on clear communication between obviously the client side and Symmetry HR. So I'm going to move into some questions now. I'm going to start with a bit of a juicy one for you, Nick. So, given the criteria for casuals getting JobKeeper and what makes a casual employee potentially eligible for leave entitlements as per the Skeen and Rossato cases with Workpac, as you've outlined, is it likely that the solicitors that specialise in class actions, like your Slater and Gordons, will advertise for casual employees who receive JobKeeper to join a class action for leave entitlements post COVID-19? What are your thoughts?
It's a really fascinating question, because you had employees really wanting to be pushed to be eligible for JobKeeper, but employers looking at the criteria going, hang on, if they're regular and systematic, and I guess it depends to the extent to which they're regular and systematic, might I be in a similar position to what Workpac was in? And I think I'd be surprised if they're not, would be the simple way I'd answer it, Wayne. I think, we know that there are 6 to 8 class actions going on at the moment. They were initially a black coal mining issue, but they've certainly expanded beyond that. I know of a number that are outside the black coal mining area, and they're an attractive thing for litigants. I know in the past 3 weeks, no, it's completely unrelated to Workpac and Scheme. In the last 3 weeks, I've had a text message from AMP or with the title AMP inviting me to join a class action as a former AMP shareholder. And I've had a text message from or with the subject line Toyota inviting me to get involved in a class action airbag case. So I've got no doubt that someone like maybe I won't use the law firm's names, but they'll probably Adero's the most kind of notorious. They'll be looking at that and going, how do we get in touch with people who are JobKeeper eligible, because they're within our scope. And the more people we bring into it, the more pressure we bring to bear on employers generally. Okay.
Yeah, interesting. Look, just as a bit of a segue into another question here, it's sort of two in one here, Nick. It's sort of a broad one with a little bit of detail in it. As we know, you are very close to the topic of casual employment, obviously via your involvement with working parties, with governments directly on this matter. What is your opinion on the future of casual employment, and how should businesses sort of, manage that? But more specifically, there was a question coming through the chat box in relation to, how do you manage casuals who are traditionally on patterned work and regular hours that's difficult to change. So it's a bit of a two-in-one there, Nick.
Yeah, I'm going to give a hypothetical situation, Wayne. So,
this will be interesting.
I would expect that at some time in the not too distant future, there will be a definition of a casual employee, and there will be legislatively enshrined casual conversion rights. They will both come with some complexities around the way the employment is established and the process for dealing with conversion, with conversion to permanent employment, and the circumstances in which it arises, and the way you have to go about it as an employer. They are going to require employers to have, well, put it in its most simple terms, it is going to be, there is going to be more red tape and administrative requirements than there have been before. So, and it's not going to distinguish between different size of business. So there's not going to be an expectation that larger businesses who've got kind of better systems and processes can deal with these sort of issues effectively, and smaller businesses get something of a free hit with it. These requirements are likely to apply across the board. I think it's going to make, it is going to provide certainty in one area, but it's going to get that certainty, you're going to get a whole heap of complexity. So if you look at that situation or that question about managing regular and systematic casuals who wish to remain as casuals, if somebody rejects a conversion to permanent employment, so if they have an opportunity to convert and they don't take up that opportunity, they lose any ability to claim permanency or make a Rossato type claim. I think that's a very likely outcome of the processes that are being undertaken now. The government's been open and public about its concern about the casual uncertainty, but they're also mindful of the risk of casual exploitation. So I think that they will try to strike a balance, and that balance, as I said, probably means that, between when they start and when they get entitled to either request or be offered conversion, that might be the entirety of your risk period. Post the conversion thing, if someone rejects it, I think the view of the government throughout the Rossato kind of process, and but being clear that the government has applied for special leave to appeal the Rossato decision, gone to the High Court to apply for special leave, there has been that you shouldn't get both. So if you've had the opportunity for permanent employment and you've not taken it, then you shouldn't be able to then claim that you're a permanent and also get the 25% additional that you were paid. So yeah, I think it's going to be a more complex world, and if you don't have systems and processes for managing it, you're going to have to work out how to get those systems or processes, or find someone who does.
So if you are just to close that one off, if you are in a position where your business model relies on casual staff, it appears from what you're saying that the There's going to be a lot more heavy lifting as it relates, particularly to businesses that manage their own casual staff. Is it fair to say that there's going to be a lot more requirements of businesses that run their own casual staff, and that you could be looking at other opportunities there?
Yeah. So I mean, if you think about it, if the government was to enact legislation that said an employer has to offer permanency to a casual employee after a fixed period of time, the first complication is that you've got to identify what that period, like, have a system that reminds you that you have to do that. If it comes with an obligation that the employees worked regular and systematic hours in that period, you've got to have a way of identifying what regular and systematic means and applying it to your circumstances. And there'll be, like there was with JobKeeper, there'll be a million scenarios that create challenges with that. So, what happens if an employee, works regularly and systematically for a period, then for a reason known to the employer goes off and is unwell or has to go overseas or something like that, and then comes back. Does their time start again? Do you take the first period, not count the second, and then add the third onto the first? It's got some complexities to it, and so I think it's you need, there's an administrative as well as an assessment complexity to it.
Okay. Look, one final question, just in relation to the Workpac versus Rossato and the casual employment, before we move on to some questions that are in the chat box for JobKeeper. A question from Mohan. Thanks, Mohan. Thanks for joining us, and we really appreciate the question. Please talk about the ASIC guidance for provisioning for casual entitlements if the appeal for Workpac versus Rossato is dismissed for past and present casuals. What comments would you make there?
Yeah, so I was alluding to that in that ASIC has, as I understand it, and I need to be clear that kind of ASIC reporting obligations and kind of auditing from a financial perspective is not kind of my area, but there's an expectation in the ASIC guidance that businesses will make a provision for what you might call permanent casual liabilities, and there's some there's some guidance that they've given as to what fits within that category. It is a really it's an interesting question because there's an increasing level of confidence amongst employers that the High Court might overturn the Rossato decision, but to rely on that would be putting all your eggs in one basket.
Yeah.
Because that they haven't even got leave. So the High Court gives special leave to appeal in about 1 or 2 out of 10 cases. My view is they'll probably get it here because it's a significant question. But what the ASIC guidance, as I understand it, says is that you've got to, in your financial reporting and auditing, make provision for employee entitlements to annual leave, personal carers leave, compassionate leave, paid public holidays, notice of termination and redundancy pay, and it talks about past and present casual employees, then employed in circumstances covered by Rossato. Now, the difficulty with that guidance, Mohan, is that is identifying what the circumstances covered by Rossato are. Like Rossato is either a very limited set of circumstances where someone had this absolute long advance commitment to ongoing employment, or Rossato is the underpinning principles that mean a firm advance commitment, and that there is a gulf between the two. And so I think what ASIC's doing is calling for, you know, a fairly broad approach to be taken to that for provisioning casual entitlements, and that would mean circumstances that are much more obvious than the Rossato situation. Because I think if you look at Rossato, it's actually a reasonably clear-cut case of someone having, you know, fairly permanent hours of work, but the principles that the full federal court spoke of go to much or to many more circumstances than just the kind of black coal mining issue of Rossato.
Just before we move on to a JobKeeper question from Michael in a moment, there's just been a question that comes through, I think, that's really pertinent. Where there is a long-standing casual through a labour hire firm on site with a host employer for a long tenure, are there risks to the host company of the engagement, or does the risk lay completely with the labour hire firm?
Yeah, I mean, we're not in the UK situation now, and we don't look like we're going to get there at any time, at least in the near future, where, you know, the ability to convert might lie with a host rather than the actual employer. So as it stands now, there's no risk for the host employer. So, you know, I think it was Glencore, maybe, who was the black coal mining company that Workpac was supplying labour to under a labour hire arrangement. They had no liability for either Skeen or Rossato, and pardon me, they would have no liability or no risk of conversion to the host employer rather than to permanent employment with the labour hire firm. But, you know, and I genuinely believe we're a fair distance away from that. I know that there's laws in the UK that have created this kind of tripartite relationship. New Zealand's gone down that path to a certain extent, but we don't look like we're anywhere near that in Australia at the moment.
So if you are wanting to be risk-free here and you want to maintain your casual employment model, one suggestion would obviously to engage a labour hire firm is one option.
Yeah, it's kind of, it's what unions complain about, but it is I've been working in the area for a long time, and it does create pathways to employment. We know a lot of businesses use labour hire casuals as their kind of recruitment and testing ground, and and the reality is it's a really effective model, and you get to kind of test the employees without the kind of risks that are attached to direct employment. And we also know that employees, you know, when they go into that path, their focus is on demonstrating their wares and hopefully winning the opportunity for longer term and permanent work with the host. And it kind of suits everyone, I think.
Excellent. Well, just want a question for Michael. Michael, thanks for your question. We really appreciate you joining the webinar today. So, and a good question as well. If casuals have been employed for the last 5 months, Nick, will the new JobKeeper ruling only affect employers with the staff that are employed from October onwards? And what happens if they were let go before the 27th of September? And if they are employed from October onwards, but the role ends in November, do employers need to support JobKeeper, or is it voluntary? Some interesting points in there, some good points. What are your thoughts?
Yeah, so there's a few parts to it. So I'll start with the first. So if casuals have been employed for the last 5 months, I'm going to, because if they were only employed for 5 months, then they wouldn't have been eligible at any time. But I'll take it that they've been working for the past 5 months, but were employed before that and were JobKeeper eligible. If they were let go today, then JobKeeper ceases for them, and they need to find an alternative, either an alternative work, or they go on to the job seeker payment that the government provides, which is essentially the social security benefit. In terms of, though, if they were continuing work through October, but the role ends in November, do employers need to support JobKeeper, or is it voluntary? Application for the JobKeeper scheme is voluntary for employers. So if you don't want to access the JobKeeper payment, then you don't have to apply for it. But once you do apply, you don't get to decide who you apply for it for. So if in this situation, if that employee whose role is going to end in November is an eligible employee for the purpose of JobKeeper, and the employer has decided to apply for JobKeeper as a business, then there's that they have to apply for that employee. The employer has to nominate themselves. So some employers have elected not to nominate themselves, but the employee has to nominate themselves. If they do, the employer is required to accept that nomination if they're applying for JobKeeper as a business. So there's only a limited amount of voluntary or voluntary nature to the JobKeeper payment.
Okay. Well, I'm mindful of time, so I'm going to any questions that don't get answered, by the way, audience, they will be addressed personally, and you will be responded to. Just to give you all an idea of what you will be receiving today as attendees and registrations for the webinar today, you will be receiving a Symmetry gift pack. And as I mentioned earlier, you will receive a free audit of your casual workforce that will step out the checks that you need to undertake moving forward. We're also offering in the gift pack 5 free online employee COVID-19 health checks, which enable your employees to go to a link and fill in a questionnaire or a survey that outlines their health and their well-being on that particular day. So really helpful tool. So it's online employee COVID-19 health checks. If you are looking to increase your headcount or do some replacements from a recruitment perspective over the next short term to medium term, Symmetry HR are offering significant recruitment discount vouchers in the gift pack today. So please engage in those. Of course, you'll all be receiving the recording of the webinar. It'll be sent directly to you. And again, just heading back to the audit, if you do want to enter into the chat box the word audit to have an audit scheduled with some legal counsel from Nick and some assistance from myself, that's more than welcome. I want to put out a big thank you to Nick Tindley. Nick, thank you so much, mate. You've been fantastic. It's great to be in another webinar with you, sharing some information and education that's really important to people, particularly in these times. It's really, really important that we're across a lot of the changes, because it's happening quite rapidly and building momentum in a lot of spaces. So well done today. I can't thank you enough. Just a quick thank you to our man in the background there, Gareth, who does a lot of work behind the scenes. So thanks, Gareth, for doing some work there. I want to thank the audience for attending today. It's been fantastic having you here. We look forward to talking to you soon. We hope you got a lot out of it. I'm sure you did. Again, if you've got any questions, you can reach out at any time. And on that note, right on 11:01, as I look at the time, I thank you for your attendance, and enjoy the rest of your Fridays and your weekends, and enjoy, people. Thanks very much. Cheers, guys.
Thanks all. Bye.